Greetings, Internet travelers. Welcome back to Influence with me, Matt Silverman. Thanks for hanging out another week on the show. And, you know, this one's coming out a little bit late because we had some evolving news and some late-breaking scheduling, but I am thrilled to be covering this topic today. You know, typically we talk to Internet creators, influencers, if you will, about what they're making, the stuff on the internet that we love to geek out about, fandom out about, and just fall in love with on the internet. But as you may be aware, unless you're living under various rocks, internet, the web, social media, not as amazing as it used to be. Still great in its own right, but there are forces at play that are feeling ickier, feeling more complicated. And there has been news recently, sort of legislation, Supreme Court decisions, things going into effect in the UK and perhaps elsewhere that feel worrisome and also feel like I'm out of my depth. I don't know what I'm talking about. I don't know what to make of these things. So I had to call in the big guns. I had to call in the experts here. And I'm thrilled that my guest today, she is a partner at the law firm Kelley Drye Warren. That's in Washington, D.C., our nation's capital for the U.S. listeners. And she specializes in the legal issues that we cover on this very podcast. It's tech, cybersecurity, privacy, AI, all this stuff that is converging on the creative spaces that we love to inhabit on the internet. And she is here to help us understand what is going on legally and legislatively with these ID laws, this push to say, hey, you need to verify your identity and put your face and driver's license and passport on the internet in order to access social media, Reddit, Pornhub, Wikipedia. There's a lot to talk about. I'm not an expert, but I need answers, and she is here to elucidate us. Please welcome Laura Riposo VanDruff to Influence. Hello.
It's great to be with you, Matt, and that warm introduction and the round of applause. Really appreciate it.
We film before a live studio audience every week here, and they're going wild. It's so nice to connect with you, and I'm eager to. I have so many questions about what is going on, and I know listeners in our Discord and listening communities have been talking about this and feeling anxious and concerned about what's going on, and I didn't feel comfortable commenting on it without legal expertise. So before we get into these topics, I would love for you to introduce yourself to the listeners and to me, and kind of maybe what have you been working on in your vast career here?
Yeah, well, I really appreciate that, Matt. So I practice at a law firm that serves a range of clients, including clients who, principally reach their audiences online, as you described. But my background extends well before that. I served for nearly a decade in the Federal Trade Commission, which is the United States' DPA, for lack of a better word. We don't have a comprehensive federal privacy law, but the FTC fills the gaps with the general authority that it has, as well as some sector-specific laws. As relates to kids' safety, which is going to be the focus of our conversation today, the FTC also has the sector-specific law of COPPA, the Children's Online Privacy Protection Act. I was in the shop that enforced that for years.
Oh wow! Okay.
Yeah. So,
I'm sorry, Laura. DPA. Can you clarify that acronym? I don't know it.
In Europe, there are authorities responsible for privacy. We don't really have that. We have some state-specific laws.
I see. Okay.
But for the federal government, there is not a one authority responsible only for privacy.
So there are government agencies in the EU that focus on data privacy, internet privacy, but we don't. We have laws around that, but we don't have a governmental body.
Not at the federal level, although the FTC fills that role because just because there's no one else to do it. And it's done it now for better than 20 years, really as a gap filling measure.
Okay. your expertise is obviously perfect for this. I didn't realize you were like in the trenches on COPPA, so I think that will dovetail into a lot of what we're going to talk about today. But I'm not sure exactly where to start, but maybe at the 10,000-foot view, the society, governments have been reckoning for, I don't know, the last 5-ish to 10-ish years about, I mean, COPPA goes way back, but I think more recently with algorithmic content, right?
Mm-hmm.
How do we legislatively, governmentally address kids seeing or being exposed to harmful content sort of inadvertently on the internet? And we'll start there. Like, what does the landscape look like before we arrive at the recent Supreme Court stuff?
It's exactly the right question. So, what I'll say is COPPA from the late 90s has related to the collection of children's information online. And in more recent years, state legislatures, as well as a number of members of Congress, have been concerned about more than just kids' information being collected online, but rather the experience of being a child online and the harms that can follow that. We've certainly seen highly publicized incidents of online bullying, as well as kids taking terrible consequences, right? Committing suicide, otherwise, and families and state legislators are concerned that there's a direct line between their activity online and what then befell them, these consequences. Mm-hmm. Even short of death, of course, just the experience of having been terribly bullied and harassed online. Mm-hmm. And so state legislatures have acted in the absence of a federal law, and there's been talk around federal laws, but none has passed, short of COPPA, that state legislatures have tried to fill the gap through a variety of measures. So, on the one hand, the states that have comprehensive privacy laws are doing more to enhance the experience for kids who are over 13, but younger than 18, but not necessarily keyed to safety. Again, still that's privacy. Right. But then there's a number of laws related to keeping kids more safe online, whether it's through design codes or age verification or everything in between. Legislatures at the state level, there's a school of thought that it's important to our democracy to allow legislatures to experiment. And that experiment is certainly coming to the fore, which is the reason that we're having this conversation.
That's very interesting, meaning that legal frameworks are designed to let states kind of muck around and try things before things get adopted federally. Is that what you mean? Like that's a practice?
Yeah, not necessarily, but that the laboratory of democracy allows, our federalism allows states to go at it themselves, unless there is a federal law that covers the waterfront.
Yep. You mentioned something that I typically lean toward in my advocacy or philosophical view, which is, I don't know what you said, design standards or design, what was
design
the term
codes.
you used? Design codes, meaning, and we're going to get into this, like, well, COPPA's COPPA, but then KOSA, the Kids Online Safety Act, which is currently in one of the legislative bodies, or
it's been reintroduced in Congress.
It's been reintroduced. And the crux of that, as I understand it, and we covered that here with your colleague Paul Singer, friend of the show, was that, hey, can we just turn the goddamn algorithms off for kids? They can search, they are free to access whatever information and communities they want. There's no restrictions or censorship. But we just turn the algorithms off until they turn 18 or 17, whatever it is. And that felt like a great idea to me, except there was something in that bill that was like, it would push platforms to do censorship, which would harm marginalized communities. Therefore, civil rights and LGBTQ rights activists were like, KOSA is bad. And then I was later told by a progressive activist that KOSA was revised and it's actually good now. But anyway, my point is, like, I want legislation that can just turn the algorithms off for kids, but not censor their experience, and let the guardrails fall to parents, not to tech companies. Hopefully that makes some sense. you know?
That approach makes sense. If you were to become a legislator, putting that in place might be challenging.
Right.
Yeah.
So, well, let's get into it. Why is it so hard? Why is it so challenging?
Well, you're starting from a place that I think is smart from a governance perspective, which is both privacy by design and safety by design. And in considering the consequences of, whether it's the algorithms or the scrolling or otherwise, the companies might make a different decision for an adult user than for a minor user. And even among minors, my 16-year-old son may behave differently on the internet than younger children who might not be covered by COPPA, but he has more maturity because he is approaching majority.
Right. Yep. I'm really glad that you have faith in my governance, and I'm pleased to announce my run for congressperson now. Okay, so COSA's in limbo, and it has been updated or revised. Do you know the status of it, and if it has addressed the civil rights challenges there at all?
So I think it depends on, whose perspective you're seeking about whether it has been, the concerns, particularly of the LGBTQ community and others, have been addressed. It remains, though, somewhat controversial, and whether it will be addressed in this session remains to be seen. So last year it was packaged with another law, COPPA 2.0, to basically extend COPPA protections to older children.
Right.
And that bill ultimately failed.
Okay.
The two have been separated again this year. There has been talk about, whether the respective committees will take up the bill. But there's quite a bit going on in Congress. I don't know if
I've noticed. This does not seem like a priority at the present second that we are recording this. So that's another story. So specifically, let's drill down to Mississippi.
Sure.
And as you alluded, like, states are figuring out their own rules and laws and whatever, as they do. And something went up to the Supreme Court, and the Supreme Court said, Mississippi, you got it. Go ahead with this plan. So,
sort of, yeah.
Okay, tell me more. Yeah.
Well, let's start with what the Mississippi law did. So, this was called the Walter Montgomery Protecting Children Online Act, named for a child who died by suicide in 2022. So a 16-year-old Walter Montgomery in Starkville, Mississippi. He had an online predator had attempted to blackmail him with the threat to release a sexually explicit video of him. Just terrible circumstances. And I can't imagine the pain that this family experienced. And so in response, the Mississippi legislature approved this statute, which requires, covered platforms. And that is defined to include things like social media, interactive platforms, to take commercially reasonable actions to verify a user's age, obtain parental consent for child users, and adopt a strategy to mitigate the harms to children by those platforms. So like sex trafficking, physical violence, incitement to suicide, etc. I have to say, really laudable goals.
Sure.
Heaven forbid there be another child that experiences this in Mississippi or otherwise.
Right.
But really difficult to implement. And this gets to your threshold question, Matt. Like, how do we do this? As just an example, Blue Sky just last week decided to block access to its social media platform because compliance would compromise user privacy and in its view, the security of its decentralized system.
Block access in Mississippi?
In Mississippi, yes.
So because Blue Sky does not want to comply with this law, no one in Mississippi with a Mississippi IP address can access Blue Sky right now.
That's my understanding from news media reports. Yeah,
I didn't realize that. Wow. Okay.
So then you asked about the Supreme Court, or mentioned that the Supreme Court said this is fine. And that's not exactly what happened, because typically and this is where forgive me if I get too legal here, Matt, but
no, please, I'll stop you. If you use too much jargon, I'll be like, wait, what are you talking about?
Right.
Go ahead.
So the way that we learned in Schoolhouse Rock, and even as civic students in high school, is that the Supreme Court considers a legal question and then issues an opinion that describes its reasoning. That's not what the Supreme Court did here.
Okay.
So after the law was enacted in Mississippi, a challenge was brought, and the trial court in Mississippi, a federal trial court in Mississippi, paused the law's enforcement because it determined that the law violated the First Amendment, among other things.
Yeah.
Then the Mississippi brought an appeal to an intermediate appellate court, and that court reversed the decision. But what begins to get wonky here is that it didn't have the kind of reasoning that's typical. There was an unsigned, unexplained order.
Interesting.
Then an appeal was taken to the Supreme Court, and the Supreme Court issued, provided on its shadow docket, so not its merits docket.
I'm learning so much. The shadow docket.
The shadow docket. That is Steve Vladek's book. Fantastic. So, without providing a full opinion, said basically that the intermediate appellate court's pause can, or rather that its decision to allow the law to go into effect remains. But there was no reasoning, no explanation from the Supreme Court as to why, which makes it hard for lawyers like me to understand sort of which way the wind is blowing. And what is particularly interesting in the Mississippi case is that Justice Kavanaugh, he issued a concurrence to this just order as opposed to an opinion. Couple pages, easy reading, but he explained that he thought that the challengers would succeed on the merits, that it violated the First Amendment, but that the challengers had not demonstrated that the harms and equities favored the Supreme Court acting in this case to stop the law.
Right.
So it is hard to understand why. Like, what more could the challengers have done if Justice Kavanaugh and maybe some of his colleagues, but we don't know, believe that the challengers will succeed on the merits? Like, why are we allowing this sea change for how the internet is going to operate in Mississippi to continue? So it doesn't give us a roadmap as practitioners about sort of what's happening here.
Yeah.
I mentioned Steve Vladek because he popularized the term shadow docket, but he also has a terrific Substack on this case from last week.
Okay, good. That's good to know. The way I'm glad you're digging in on this, because it's like this sort of like very casual, like, yeah, whatever, it seems fine motion from the, not legal motion, but like this very casual thing from the Supreme Court does have huge ramifications for how the internet functions in the United States. And I want to just understand the challenge, because you're talking about First Amendment. My assumption, which might be wrong, certainly is probably wrong, is like, I thought this was about the ID verification. My concern with it is less about First Amendment, but more about like, hey, kids need parental permission. Great. Kids should have privacy protected and algorithms off. Great. Everyone in Mississippi needs to put their ID into the internet to use Facebook. That's not good. But that's not a First Amendment thing, right?
Well, it might be, because it burdens the speech of people in Mississippi.
Got it. So is that what the challenge was about? Was it about the ID?
Among other things, as you can imagine, the challengers brought a number of arguments, but included that, burdening the speech of both the platforms and the who do some editing, right? That editorial decision making is speech, and that the residents of Mississippi have just huge consequences of this. Got it.
The burden of access to speech, that's an interesting concept that I've never heard before, but that makes a lot of sense. Do you happen to know offhand, like, so it's that, and what were the other pieces of the challenge, or a handful of them that might be relevant? Do you know? Like,
gosh, it's been a while since I read that briefing, so no, I don't have that offhand.
No, no, not a problem. But this is getting at what we're hoping to cover today.
Well, and it's frustrating, right? Because we don't know what resonated with the court.
Totally. So, okay, we don't know what's up with the Supreme Court here. So, like, what's next? You alluded to this as a practitioner. You're like not sure which way the wind's blowing. Like, so are you just waiting for the shoe to drop? Like, what happens in your world?
Right. So, this reporting about the actions that Blue Sky is apparently taking is an example of that. I mean, fully
Okay.
expect that the challengers will continue to press. Justice Kavanaugh said that he thinks they're going to prevail. So, in terms of putting a thumb on the scale, that is certainly a sign that their arguments have terrific merit.
Mm-hmm.
But in the meantime, covered platforms are faced with a choice about how to proceed here and what that means both for Mississippi and maybe elsewhere in the country. I think we have to wait and see what happens.
Yeah, and I'm fascinated by this idea that you could be living in one state in the United States and you open up your internet and it's like, sorry, this website's not available. And then you use a VPN or you hop over the state line and it's like, now I can go on Blue Sky. And Blue Sky is an interesting example because I'm a little hazy on the details, but it's a decentralized platform. So Blue Sky is like run by somebody, but like I can fork that into another version using ActivityPub or whatever. And is that covered by the law? If I run a Blue Sky server out of my house in Mississippi, and I want my friends to all join a little chat room, do they all have to give me ID? Like, how does that? Maybe I'm asking too granular a question for you right now.
And I don't know, right? Because it may depend on how companies choose to operationalize requirements or otherwise. I mean, we certainly saw in the wake of the CCPA that there were companies who implemented. And this is the California privacy law that went in. It was the first state to implement comprehensive privacy legislation. And so
when was that roughly?
So it was. It's been 4 years that's been fully in effect.
Okay.
But in the early days, even before the penalties were applicable, some companies had California, they geofenced California, and there were rights available only in California. But as more and more states have come online with comprehensive privacy laws, we're seeing companies try to come up with a solution that works across all 50 states because just the operational difficulty of distinguishing between states is really a challenge.
This reminds me a little bit of GDPR, which was like the EU made privacy laws, and then all of a sudden, every time you open a website in the US, it's like, hey, accept our terms of service. Hey, here's all our cookies. And you're like, what is happening? And it's because Europe made a change, and websites don't want to make two different websites. They just want to run their business, So
exactly.
Yeah. Okay. Listener and Discord member Zdar has a question for you. They ask, can she speak about what makes Mississippi's law especially onerous? Also, why is this is about the EU stuff, which we're going to get into. But Zdar is asking, is there like a religious factor? Are there forces at play that are sort of like religiously conservative minded that are influencing these laws? Or is it, like what are the factions that are pro and against certain aspects of this? Because like you said, we don't want kids to be bullied and trafficked and commit suicide. Like everyone can get on board with that.
Right.
But there's more perhaps under the surface is what Zidar's kind of wondering.
I think it's an interesting question, but I don't know that it's partisan, and I don't know that it's motivated necessarily by religious sentiments. I think that there is a sincere desire to protect children, but that the technical sophistication of some of these part-time legislators might be limited. And so, as states approach doing this somewhat differently, the expertise that they bring to bear on the solution might not match one-to-one with the experience of how platforms even operate.
Yeah, which I talk about a lot on this show is just, and in general, of like, how can we have a society when nobody making the laws or rules knows how anything works? I'm not a programmer. I don't know how anything works, and the people in charge don't know how anything works. And so we have tech companies just doing whatever they want, and that's a larger issue. Let's pivot a little bit over to the Online Safety Act, which is in the UK. And I know you're a practicing attorney in the United States, but do you interface with European laws in this way? Do you practice with this?
So I don't practice in Europe, but this is, I think, front and center, if for no other reason than the legislators in the United States, as well as the Trump administration, has made this a priority. And the Online Safety Act, which is I think where you're headed, Matt, purports to have extraterritorial reach. So that, I mean, to reach not just companies operating in the UK, but companies that reach the UK. So from the United States, for example. Well,
because these are obviously global multinational companies, but from a user's perspective, if I log into Reddit in the UK, I'm going to get a pop-up that says, please upload your ID. And if I log into Reddit in New York, everything's the same, right?
So I that is my understanding. Have I tried to log in from London? I have not. But this has raised concerns. We saw that Representative Jordan just yesterday held a hearing about this, and Nigel Farage from the UK came over across the pond. His Reform Party has a quite a conservative platform, but among them is to repeal the OSA, which just interesting that our legislators would spend time on exactly this issue.
Yeah, because like as you said, it's all interconnected,
right?
And just to put a fine point on it for listeners, in case I don't know, the point of the ID stuff is like, hey, if you're a child, prove that you are, a child, and that's not the worst idea. But as an adult user who wants to use the internet, sometimes as a public person, as my real self, and sometimes as an anonymous user, the burden on all adults to verify their own age to use Reddit or pornography sites or social media sites, like that is, in my opinion, is bad for a lot of reasons. Among them, what if the government leaks or loses my data? What if the intermediaries that verify my ID get hacked? Like, what if a government becomes an authoritarian government and then uses my ID and my social media habits and my web browsing habits to zero in on me as a dissident or whatever? So like, what's going on there legally and ethically and philosophically in your world right now, or discussion wise, obviously?
Right. So, I mean, I think you've raised a number of concerns that are shared by many in this in the Trump administration. And I think more fundamentally, when we talk about things like privacy by design, that means that, as you're designing both a product, but also an interface, you think about principles like not collecting more information than you need to deliver the service. Right. And when you then have the intermediate step of needing to provide, what in most jurisdictions is a static ID that is the key identifier to whether it is new financial accounts or otherwise, right. It runs headlong into privacy by design, because you don't need a driver's license in order to engage on Reddit, but because of this law, then that is required. It creates exactly the risks, Matt, that you were talking about. Misuse of personal data, both by companies and potentially by the government. The concern that I'm most worried about, and this is an issue sort of separate from these kid safety laws, but that I counsel clients on quite a bit, is reducing the risk of information security incidents by really understanding what information you have and whether it's necessary to collect it in the first place or keep it. And so these laws really increase the surface area of risk if what you're doing is asking companies or their vendors to collect highly sensitive information.
There's a little bit in the weeds, but like I know this from managing various, I think it's YouTube, where YouTube is like, hey, if you want to be in the partner program or you want to use these features, upload your driver's license to make sure you're a real human being and not a bot. And then I get a message maybe 3 weeks later that's like, hey, we verified that you're you and we have deleted your ID from our server. Now, whether I believe Google or not, that's a different story. But it made me understand that like we need to verify you for purpose X, and then we delete data so that you're no longer in our system, but you do have the green check mark that's like, yep, you're good to use features XYZ. Is that a solution? Is that a middle ground for this? And can we trust? if the law says, hey, delete the ID once you verify, is that a way forward on some of this?
Well, I mean, that may address some of the concerns. There may be other ways also to estimate age that don't require collection of personal
some
identifiers.
of this is like they're using AI to verify which users are kids and which users are adults, which is just bananas.
So it may have some unintended consequences, but we saw, for example, Google in February announced that on YouTube, so go back to your YouTube example, that it would begin engaging in age estimation to ensure that that children were receiving age-appropriate experiences.
Right.
And I don't know that they have so many data points from users' interactions on the platform. I have no insight into how they do this, but I can imagine a world where they really can distinguish between my 16-year-old and a 4-year-old, because their uses of YouTube would be very different.
100%. Yes. They can do it, and they definitely do it, but they do it in pursuit of advertising revenue. They just want the user to stay on the platform with the content that is most engaging or clickable, so they can, increase profit. It's not, I don't know that it's in service of, safety, or I'm sure that's an ancillary part of it. But anyway.
Well, I think there's an argument to be made that the platforms want to stay ahead of these kinds of initiatives and offer, you described it as a middle ground, but offer a solution that is short of some of the more extreme proposals.
Right. And again, the solution is just turn the algorithms off. Just stop suggesting content to minors until they're old enough to say, yes, I want algorithms. And that's a layperson's view of like, and of course my cynical view is like, well, they don't make as much money if they can't target content and advertising to everyone, including kids, which make up a huge billions and billions of users on YouTube, especially. That hits them in the pocketbook, which is why they are waiting. I don't know. They need to be compelled by laws to do some of this stuff. And I'm postulating here, but I don't know. Do you have thoughts on that, or disagree?
I don't know. What I would say is, state legislators want to address a number of risks to children in terms of safety. And it's not just about, the algorithmic feeding of content, whether that means that you go down a YouTube rabbit hole or otherwise, but it also includes things like, getting DMs from, the mean classmate and, across the lunchroom who, wants to really bully you about, I don't know what. So it is, they've come up with blunt instruments to try to address all of those harms.
And I think, obviously, the bullying and the social pressure of social media is real, and it's a real concern for kids and families. But I view that as a parenting issue, not a legislative issue. Like, I don't know that burdening the companies to like, I don't know, police the DMs. Anyway, so it's a larger issue or a larger conversation. But anyway. Yeah. So we talked about COSA. Well, I mean, what has been in the UK, and you've alluded to how it's affecting the wider world and the US, of course. Right. But like, I read or was listening to something recently that's like VPN usage in the UK has increased by like 1,000% because everyone's like, I'm not uploading my face to Pornhub. I would like to get around that and pretend I'm in Italy or, Iceland today, and therefore continue using the internet. So like, it's not really a legal question, but like instantly there's this sort of user pushback against what is asked of them. Like, I don't know, any thoughts or observations on that? Like, obviously Blue Sky, you're saying, is changing its policies around the Mississippi situation. Like, we're literally in the thick of it as we are speaking here. It's all unfolding before us. Yeah,
so interesting. And just last week we saw 4chan and Kiwi Farms bring a suit here in the United States to prevent the UK regulator from enforcing or attempting to enforce the OSA in the United States. And it's not exactly for neither 4chan nor Kiwi Farms do I think of as necessarily being the model platform of like no harm to any children, but rather, really bringing some fundamental challenges to, whether the Online Safety Act can comport with constitutional protections in the United States.
Strange bedfellows when we are rooting for 4chan and Kiwi Farms to bring lawsuits and succeed in their quest for free speech.
Well, and let me just, because I'm in Washington and I can't help myself, I mentioned Jim Jordan, but we've got, Congressman Jordan and Senator Wyden, who, really are very different politically, both concerned about the OSA.
That's very interesting.
So just strange bedfellows indeed.
Strange bedfellows indeed.
Yeah.
I've also heard some chatter, and tell me if it's misappropriated or misguided, but like under the UK law that Wikipedia might be categorized as a site that has interactivity and therefore requires age verification. And that really is upsetting and terrifying to me because it's the fount of knowledge, and if people can't access it or access it quickly and freely, that's talk about burdens. Do you know if that's actually the case?
Right. So the UK regulator sorts platforms into different categories with different compliance obligations, and Wikipedia was, according to the regulator, found to be in the same category as Facebook and YouTube and TikTok. And so facing the strictest of duties.
Wow.
Now it brought a challenge.
They brought a suit, Wikimedia Foundation. Okay.
Right. And I'm no expert in European or law in the United Kingdom, but the High Court dismissed Wikipedia's initial challenge. It really did leave the door open to future litigation if this categorization proves to be harmful, which I struggle to imagine how it wouldn't be. Right. But Wikipedia, is really concerned about the future of its service, that this is a real threat.
Man, and we've covered it on this show. Well, what about ChatGPT? Is that categorized in this?
That's
these
a really
buckets?
Interesting question. I don't know the answer. Yeah,
because we've been talking about it here with various folks, Wikimedia folks, and others, where it's like generations of kids are starting to go to ChatGPT for information rather than Wikipedia, which then harms the user base of Wikipedia, and people get exposed to Wikipedia less, which then makes them less likely to participate in Wikipedia as a volunteer. And the reason I'm bringing this up is like, if Wikipedia is blocked or burdened in your country and ChatGPT is not, it just kind of funnels people to AI knowledge solutions, which are fraught, rather than community-based knowledge, which is the miracle of the internet that we want to continue to see happen. So anyway, it's not really a question, but more of a sad observation. You mentioned in our chats before getting going here, the U.S. FTC brought a lawsuit against Pornhub, or not a lawsuit, a fine.
So they settled an investigation together with the Utah Attorney General, and that was announced just yesterday. That's right.
Oh, yes, very recently. And this is about, well, you explain it. This is about not harmful content, but like child predation content on the platform. How did you explain it?
Exactly right. So the allegations in the complaint, and the way that this works, Matt, is that when an FTC investigation is settled, the FTC will release a settlement complaint and an order that resolves it. So typically the company at issue, there's no admission of even the facts. So these are just allegations from the FTC, but the allegations in the complaint that was released yesterday were that the parent of Pornhub provided access to tens of thousands of child sexual abuse materials, CSAM, as well as non-consensual materials. So this isn't just kids, but concern about rape, revenge porn, etc. And the concern or a couple of things. So the general law that the FTC uses, and state attorneys general have what they call mini FTC acts, but it prohibits unfair and deceptive practices. So
Okay.
in this complaint, the FTC alleged that the parent of Pornhub often failed to remove content that it had already flagged, that even after it had banned people who uploaded CSAM, the child porn, those users could re-register. They didn't take sufficient action to prevent re-registration.
Okay.
They didn't do things like fingerprinting technology. They made representations about content review that were deceptive. And they also said that they required age verification documentation for paid content, but didn't maintain that paperwork. So, among other things, I mean, it goes on from there. It's a long complaint detailing, I think, a years long investigation. If I'm putting if I'm drawing the right inferences.
Okay.
But effectively, that Pornhub harmed children, and that together with the Utah Attorney General, so the FTC can't, under this authority that I'm describing, can't secure monetary relief because of a Supreme Court case from a few years ago.
Oh, interesting.
But Utah can, and so there was monetary relief in the amount of $5 million in the settlement that was announced yesterday.
To my mind, is couch cushion money. That seems so low for a huge tech company. I forget the parent company of Pornhub, but they're
ALO apparently.
Okay, I didn't even know. Yeah, so maybe this is more of a legal nuance question, but like obviously, if CSAM content was identified and was really there, and these precautions and lockdowns were not done, then this is good. But
right, I think that's right.
But does this? Yeah, do you feel this connects to the larger conversation about privacy with these platforms? How do you connect the two?
Well, the way I would say that the bar, so lawyers who practice in this space, have been waiting to sort of see what the Trump administration's Federal Trade Commission, what the FTC under this administration, where it would draw lines. The various commissioners appointed, the various Republican commissioners, have made statements about wanting to protect children, but it was hard to sort of understand how they would do that. They had different priorities than someone like Alvaro Bedoya, who served as a commissioner until February of this year.
Yep.
So it's, I guess, in a regulatory environment where federal regulators are exercising enormous restraint, I find it gratifying to know that the Federal Trade Commission will take action to stop egregious content, because I don't think that there's any debate about CSAM being harmful, and that lies about how you're protecting against CSAM are actionable. So that I think is gratifying. In terms of how it connects to the others, I think that the connection is attenuated, right? Because the determination by state legislatures is that the protections offered by current federal law are insufficient, which is the reason that state legislatures are going further to provide for more protections for kids online.
Right. And is there something in this that's like, we have these laws that seem like they're violating privacy, or that they're overreaching on privacy, et cetera, and are they going to then be justified by sort of adjacent or unrelated stuff where it's like, see, there is bad stuff on Pornhub, therefore we must protect the children? Is there like a social hearts and minds, thing going on here? I know this is beyond your, brass tacks expertise.
I don't know that it is. I mean, again, I think this was a years-long investigation, so I don't know that it was an effort to justify activities in other jurisdictions and other spaces. But it's not to say they won't be used that way.
Right.
We'll have to wait to see.
So before I let you go, what's next? And the answer might be question mark, but there are challenges. We're waiting for things to get enforced or not enforced. Like, you are in this all day, every day. what are you glued to? What are you waiting for? What are you working on that is, relevant to this conversation?
Yeah, I mean, I think so. The industry organization NetChoice has brought challenges to nearly every one of these state laws, and it's been successful in nearly all of them. But it's at the margins where courts have carved out, for example, in Texas, allowing age verification for access to social media and to pornography.
Right. I saw that in Texas. When I was reading, I was like, oh, right, it's Mississippi, but I thought it was Texas, but it is Texas also.
Right. So the Supreme Court, the opinion in Texas, there is like a full opinion as opposed to just this shadow docket order.
Okay.
Really, among other things, distinguishing between the harm to kids. And so I think we need to see how the lower courts apply that holding. For the most part, I think we're going to continue to see industry prevail because the First Amendment protections in the United States are robust. Mm-hmm. Even Justice Kavanaugh thinks that, Mississippi, that there's a problem with the Mississippi law. Okay. So, but I think it's going to take time, and the internet doesn't move slowly. So there's a real tension.
You're making me think of one more question, which is like, if I'm an internet user in Mississippi, aren't I protected by federal statutes of privacy? Why do I have to comply with my state if the federal says something different? You know what I mean?
Right. So yes. So this is the principle of preemption, where there's different kinds of preemption, but basically, when a federal law occupies the entire field, then state law is basically superseded. And that's just not the case in the United States because we don't have comprehensive federal law.
I see.
And one of the debates around whether there should be is whether it would preempt the various state laws, and that ended up being the poison pill a few years ago when Congress got very close to passing federal privacy law, but that was the sticking point. It largely because of California, because California had been so successful with CCPA that the California delegation, which included then Speaker Pelosi, just did not want to see it happen.
Right. I guess this is analogous to like, I can use cannabis products in this state and this state, but if I go to this state, I can't, even if there's a federal, even if things are different in different places. So I suppose that's somewhat similar to these privacy regulations.
Yeah, I mean, we live in a federalist democracy where our states are empowered to do different things.
Right. Well, Laura, thank you for elucidating all of this stuff. You've answered so many questions from me and listeners. If folks want to follow your work or connect with you, is there a play? Are you public on the internet, or where can folks find you?
So I mean, our law firm certainly has a website, like every law firm. I'm on LinkedIn. Those are the two best places for me. Excellent. Professionally.
We will link to those places in the show notes and the video description. Laura, thank you so much for coming on the show. We really appreciate it.
Wonderful to be with you. Thank you, Matt.